You're now live.
Okay, we are live and we are back from break. We're going to continue our discussion on student weighting and cost equity, and we're deciding everything other than ELL if we're going to be doing weights, cost equity, or some mixture thereof. And our witness today is Mark Schober. Did I massacre it?
No, not a massacre. It's Mark Schauber.
Schauber, for the Coalition for Vermont Student Equity. So, Mr. Schauber, welcome. And the floor is yours. We just ask you to introduce yourself and who you represent for the record. And then tell us a little bit about the Vermont Coalition for Student Equity and what you'd like us to hear.
You got it. So my name is Mark Schauber. I am the executive director for the Coalition for Vermont Student Equity. We're a coalition, a nonprofit coalition of school boards from all parts of the state. We currently represent 25 districts, more than 19,000 students from 11 counties and 80 cities and towns. We joined together a little over a year ago now for the sole purpose of advocating for the implementation of the recommendations from the Pupil Weighting Directors Report. We're made up mostly of underweight districts, but we do have some overweight districts, including Peachum and my own hometown, Dover, who have joined us because they realize that equity doesn't mean winners and losers, but that everyone gets what they need to succeed. I have submitted my full comments in writing to Faith. I think given that the draft bill came out today and our coalition hasn't had a chance to fully analyze it yet, I don't want to spend too much time or waste your time going through my comments in great detail. In general, we're encouraged with the direction that you all are taking, and appreciate the emphasis on continuing use of the weights and the implementation of the recommendations from Professor Colby, all of her weights. Excuse me. I'd have I think just a couple of small topics that I just want to touch on quickly with you. One is the poverty count. We were very happy to see the universal income form as part of your bill, and believe that is the way to move forward. We have some concerns about the free and reduced lunch and the undercounting of some poverty students, especially in high poverty areas and in rural areas, because of COVID and the universal meals that we have from the feds now, and districts that already provide universal meals. So we just encourage you to implement the universal form as quickly as you can. And then last, I guess I'd just say that we appreciate as speedy as an implementation of the weights as possible. These districts have been underfunded for essentially a quarter century now, and could really use the help. Like I said, you have my written comments. I don't want to spend all your time going through them since we didn't have a chance to evaluate all the details of the bill yet.
Okay, well, the bill, it's a committee bill and it was drafted just right for the moment to reflect the recommendations of the task force. This committee will now proceed to go through it line by line and pick it apart. So if there's something you think we should know, let us know.
Excuse me. Well, I think I'll say that if in regards to, cost equity versus the pupil weights, I think one of our biggest concerns is that with cost equity, you don't really have equity because you're taking an average amount throughout the state. You essentially have a bell curve where you've got, some districts that are going to get the average, and that's going to be what they need. And you can have a lot of districts that get more than they need, and a lot of districts that get less than they need. And you don't have that with the weights. They're designed to overcome that. Excuse me. See. Just give me a second to get my thoughts together. I think that as I mentioned, the poverty count with the free and reduced lunch is a concern, but the universal income form solves that problem. And sorry, let me just pull up some, if you don't mind. Let's see. So I think you've heard a lot from the VSBA and the superintendents, and we believe that, like I said, and it's in the bill, but that your inclination to adopt corrected weights as opposed to going with a cost equity model is a wise decision. And some of the reasons for that would be that, like I said, the cost equity model won't provide equity to all districts. The current weights work within our existing system, and superintendents and business managers understand that system. And as you've heard from Professor Colby, the weights are designed with cost containment in mind. I think it's going to cover it for now. You have my comments, and I think that they kind of speak for themselves. I don't want to go through every bullet point, but there's no question that we're encouraged with the current bill, and hope that you will continue advancing this draft without too many modifications.
Questions? Mr. Schauber.
Sorry, the sun's making it hard for me to see anything.
We look forward to reading your testimony. I know it's been posted.
Great, thank you. I appreciate it very much.
Okay. We're going on to S53, which is the corporate income tax bill. And I'm waiting to see Bill Driscoll is going to be talking, and Abby, but I think we can stand at rest here for a couple minutes till they show up. Next week, we're going to continue on this one. We're going to continue on the corporate tax, see if we can come to some resolution on either one of them. We'll do a little more testimony on 166. And then I am going to take some testimony on attached to S53. It's my understanding there is a limited exemption for military pensions, and we also have a bill for federal employee pensions. Both of those groups do not pay Social Security. So that this is in essence their social security payment. So I thought we might look at some equity there. But we'll just throw it on the wall. Is that it, Senator Hardy, and see what sticks? We were throwing spaghetti this morning. Okay.
Right. That was my analogy for health and welfare.
It ain't, was it? No, it was after there was in health and welfare.
Yes.
It's as good as the process we use. Okay, I see Bill Driscoll has joined us. Bill, we're a few minutes early, so I'm glad you were here. Yeah, despite the title, this is the corporate tax bill, and going to the single sales model, going from Joyce to Finnegan. We're told going to single sales should help Vermont-based or corporations with larger presence in Vermont, as opposed to those that just sell into Vermont and really have no nexus here. But we wanted to hear from some Vermont-based businesses or businesses that are here, and see what you think, how this will impact your members.
Sure, and thank you very much, Madam Chair, for the opportunity to speak on this bill again. This is definitely an important.
We're having a little trouble hearing you, Bill.
Okay, can you hear me at all?
Yeah, it's a little better.
Okay, not quite sure. Let me know if there's a problem with the volume. I can try to see if I can fix that. Hold on just one moment here. Microphone. How's that? Is that better?
That is much better.
Okay. I think my computer must have reset itself at some point. Apologies for that. But for the record, William Driscoll with Associated Industries Vermont. Like I was saying, I very much appreciate the opportunity to speak to this bill. We were gratified by the broad support it had in the House and from the department, and we certainly appreciate your giving it serious consideration as well. And also, I think it does help that you are trying to focus on this set of corporate tax changes as a package. I think it helps focus the arguments for the legislation. So I think it might be helpful just to reiterate from the sort of from the sector perspective from manufacturers as to why this is a positive change for Vermont, and try to address maybe some of the questions that have come up about some of the provisions that I'll try to address and clarify. And then there are, although we're supportive of the package as a whole, there are some provisions we just want to flag some questions or reservations about that the committee might want to consider further. But generally, this is a positive move forward overall. We're an organization that represents and advocates for the manufacturing sector. We certainly support businesses beyond manufacturing as well. But as you might imagine, one of our top priorities is to support and encourage employment and capital investment in production here in Vermont. And the reforms here before you as a whole really do promote that, and we feel it'd be an important change. Again, this, you're encouraging companies that basically are here physically, but they do a lot of exporting of goods and services outside of the state, which has a great positive impact for the Vermont economy and Vermonters. Now, in the concept of single sales, you kind of already addressed that for services by the adoption of market-based sourcing last year, and so this bill would sort of complement that and continue that transformation to include tangible goods as well. And I think I'm sorry.
Nope, I'm just going forward. We're getting some strange feedback. I don't know what's swishing, but we can hear you much better.
Okay, I'll try to stay still while I talk, maybe.
Okay.
When we first, we've been advocating for this for a number of years, and when we started, it had not been as widely adopted around the country. So it was really seen as an opportunity to create a competitive advantage for Vermont companies by making the transition. I think, as you've heard, now that we're sort of tipping past the halfway mark in terms of states adopting this, there is still opportunity for this to be a competitive advancement for Vermont. But we're also entering a period where we also need to adopt this to avoid more of a competitive disadvantage. And I think that, people, I think you've heard quite a bit of testimony on this and other topics. It can be hard to quantify the economic benefits of policies like this, but I think this really can't be denied that this puts Vermont manufacturers and other physically Vermont-based corporations in a better financial position and with improved costs of doing business in Vermont. And that is bound to have a positive impact across the board. There's been some question about the size of companies that are benefited. And that's, moving to a single sales factor in and of itself does not discriminate or distinguish between larger or smaller companies. It is simply how do you allocate or how do you apportion income of a company relative to where your production and employees are and relative to where your sales are. So you could have a very large company or a very small company, and they will benefit the same relatively depending on that distribution. So it's not a size distinguishing reform. Now, that being said, certainly there are more C Corps among the larger end of businesses and more S Corps along the smaller end of businesses. But that's not necessarily a clear, steady line. And so, there are certainly many large and small businesses that will benefit the same way. And beyond those sort of practical benefits for the state and for state companies and their employees, there is the sort of philosophical, sort of good tax policy approach where if you're trying to find an analog for income so that you assign income fairly among states, sales would seem to be the most direct and most clear analog to that. So it's a good measurement by which you try to allocate taxable income across states like that. And again, obviously, states are definitely moving in that direction more and more. And even within Vermont, this is also a conforming change, if you will. Like I noted at the outset, that's in line with what we've done for the taxation of service companies as well. So there's just positive reasons sort of across the board as to why this would be a good change for Vermont to adopt. I think it is important, though, to focus, although it doesn't seem to be as big an attention item, but I think it is very important that we have included in this package the repeal the throwback rule. I think there are a lot of important reasons to repeal this particular provision. One of the biggest ones is that it can be very arbitrary and almost not entirely rational how it would affect different companies. I think we've made the point, and I believe Senator Brock brought up this example as well earlier in the week. Because throwback impacts a company just because their customers might be in a state where they don't have a taxable nexus. That can create a lot of sort of arbitrary impacts. If you have two identical companies, insofar as they both have the same amount of sales, they both have the same amount of Vermont sales, but their out of Vermont sales are in a different mix of states, with some having a nexus and some not, you could have those two otherwise completely identical and identically performing companies have very different taxable income in Vermont, because one state might just randomly have some sales thrown back into Vermont compared to the second company. And we just don't feel that is a sort of a good or rational tax policy. Similarly, you could have the same company, and that same company might have the same sales year over year, same Vermont sales year over year, but because one year they had more sales in this mix of states, and the next year they had more sales in this other mix of states, they could be taxed very differently year over year just because of the throwback rule, without regard to anything that's of particular relevance to Vermont itself. And given Vermont is not a large market itself, so it's not hard to see how it may not take much in terms of one or two or more additional state sales being thrown back into Vermont to have a fairly large, for that individual company, a fairly large relative impact on their tax liabilities. Moreover, and I don't know if there are studies or statistics to demonstrate this. I'm saying this as something that this would seem a reasonable concern to us, and it's certainly a concern that we have. Again, keeping in mind that the companies that are hurt by the throwback rule are those that have states out there where they're selling products, but they don't have a taxable nexus. If you look at the spectrum of corporations who would be covered by this legislation, our concern is that the larger end of the companies, the ones that are going to be part of probably larger affiliate groups, multi-state, even multinational corporations, they are very likely to have a nexus, in most places. It's the companies on the smaller end and the more independent corporations, the ones that are not necessarily part of a larger affiliate group across states. Our concern is that those are the ones that are going to be especially at risk of having states out there where they don't have a nexus. And therefore, those companies might be proportionately more at risk of running into difficulty or costs associated with a throwback rule. So we think that there's all those reasons to repeal it in any case, but I think that concern about the potential for greater sensitivity or greater impact proportionally on the smaller end of businesses that we're talking about is just an additional reason to look at repealing that. I know the concept of trying to fight or counter tax avoidance strategies was brought up by Graham the other day. I think my sort of thoughts on that, I can't speak to how prevalent or how significant a concern that really is. I'm not sure it's a serious issue for Vermont. But another thing to keep in mind is also, I'm not sure how effective the throwback rule may be in sort of plugging those gaps or addressing that in any case, because, although throwback brings back income in states where a company doesn't have a nexus and there's a tax, but it doesn't address those situations where a state has significantly lower tax rates than Vermont, and it doesn't address the several states that have no corporate income at all. So, even if for the sake of argument, there's a concern about companies trying to plan their ways around allocation of sales to Vermont, there would seem to be plenty of opportunities for that are not going to be addressed by throwback anyway. So I think that muddies that area a bit. But even regardless of all that, we still come back to those sort of arbitrary and almost capricious effects that I outlined before. And we feel that we shouldn't be exposing Vermont companies to those kind of vagaries of taxation that really don't have a rational basis in terms of looking at Vermont and sort of the whole intent of single sales reform of focusing Vermont taxation on Vermont activities. So those are the two, two particularly large areas of benefit. The move from Joyce to Finnegan, I think that's obviously also largely a conforming issue. I think that plays into both the single sales change and the throwback change in ways that I think accentuate the effect of shifting the sort of the tax burden away from Vermont-based companies or Vermont employers and producers, and onto more out-of-state companies that are simply selling into Vermont. So I think that on balance is is certainly a reinforcing reform. It also addresses obviously those folks who have concerns about what the sort of face value revenue impacts are, and to the extent that folks want to try to even that out as much as possible. Obviously, the move to Finnegan can help address some of those concerns, and it was reassuring on that front that the analysis that you've got most recently, particularly including the market-based sourcing change, does, I would hope, alleviate a lot of the revenue concerns that folks might have had about this overall package. Just to be clear, the two other provisions that I would flag. The first one is the repeal of the 80-20 rule. This is not a significant reservation on our part. The 80-20 rule was sort of an artifact of the move to unitary combined reporting in 2004, effective 2006. That was really meant to address an area of uncertainty and potential litigation that was just easier to avoid with this rule. And I don't think we need to get into all the complicated history of that. Our only sort of thought there, all things being equal, we would have preferred a slower move into that, just so that we had a better idea of what kind of revenue impact and sort of like a revenue shock impact might be on some companies. And also, and this was brought up in the House discussion of this issue, Vermont has a number of different ways it taxes foreign income and foreign business activity that's a lot more aggressive or higher than most other states. And so the question arose, and I can't speak to this is why I kind of think it's important to look at this issue further, whether a lot of the revenue that's not being taxed because of the 80-20 rule is effectively being captured otherwise. And if you remove the 80-20 rule without addressing those other things that Vermont's maybe doing different than most states, are you creating an imbalance or a competitive issue? I only raise that just as something that maybe would be good to get a better handle on. I think the ultimate intent of eliminating the 80-20 rule and effectively taxing those corporations, just like every other corporation is taxed in Vermont, is a perfectly logical and reasonable thing to do. So, regardless of how that timing is done, if it's continued to be a part of this bill in the timing that's in this bill, we can certainly accept that. We would just encourage that we also follow up on that with really kind of looking at foreign income, foreign activity taxation in Vermont. This would be an important issue to review. The last item where we had maybe more discomfort or more concern is with the alternative minimum tax, and that's largely because I think there's a general principle where if you're taxing gross receipts of a company without regard to whether they have taxable income or whether they have even losses, and particularly without understanding why they have those losses, that just raises a lot of concerns if you're going to have a meaningful tax bill on those folks, regardless of that. That's an issue as a general principle. And in terms of practicality, and competitiveness, this AMT schedule that S53 has is pretty extreme compared to other states. It would definitely put Vermont out there. And because we're not entirely sure about where that burden is really going to fall, what the impact of that burden might be. we would certainly prefer the committee to consider if you still want to have an additional provision for additional revenue to sort of run the balance out that you're seeking, to consider potentially other provisions. I know the department raised, I think, sports betting or something like that. Obviously, Associated Industries of Vermont, it doesn't really have much to say one way or the other about sports betting, so I'm not going to say that that's our recommendation. I'm sure I'm not going to say we're going to impose it, but I think it might be worthwhile for the committee to consider another piece to fill that particular offset role. But even if you want to stick with increases in the alternative minimum tax, it may also be worth looking at the way, looking at more, could there be a way to design it that has more safeguards, if you will, for particularly for Vermont-based companies that we're trying to help in this overall sense. Just one thing that makes me think of that, in the comparison, or when they were looking at the AMT in other states, again, this was definitely an outlier, but even I believe it's New York, which also has a very aggressive alternative minimum tax schedule on its face. I think one thing which I'm not sure it may have just been overlooked, or I don't think it was really discussed, is they actually have a second schedule that's significantly lower, and that is it appears to be for a fairly broad swath of manufacturing, mining, agricultural production, emerging technology. In other words, a number of companies that are either entirely in-state or have a significant contribution to the state economy, and that they have a different treatment for those companies. I am assuming in part to maintain sort of a competitive and supportive environment for those companies. So at the very least, that might be something the committee, might want to consider, or at least keep the door open as this session continues. So that certainly support this package as a whole, but if there's a way to address that sort of lingering concern or uncertainty, particularly with that provision, we would certainly encourage that. So I hope that wasn't too long or repetitive. I hope I caught some of the questions or conundrums that folks were trying to wrestle with. But if there's anything else I can try to address either now or get back to you on, I'd be happy to do so. Because I do want to emphasize, this is definitely. I think this legislation is going to do a lot of good for the state, and I think we're very appreciative that you folks are working on it.
Okay, thank you. Are there any questions for Mr. Driscoll? None. Okay. Senator Sorotkin. Michael, you're muted.
I said, welcome, Bill. I had a question on the last thing you were talking about.
Mm-hmm.
So you're saying that alternative minimum taxes should be sensitive to, you said something about we may charge an alternative minimum tax to a company that has a loss, and we might want to look at profits in terms of, as opposed to receipts in terms of setting an alternative minimum tax?
Well, yeah. So that speaks to I think that speaks to the principle of certainly having any significant alternative minimum tax. If you're only looking at receipts, receipts don't necessarily mean that company is profitable or actually has net income. And it taxes that company regardless. So if you have a company that either has virtually no net taxable income, or frankly even losses, you can end up taxing them regardless, and you're really basically adding to their losses with a tax bill. It would be, and that's.
I thought in essence, when I hear about this on the federal level and stuff like that, that's precisely the intent, is to make sure that corporations pay something, even if their balance sheet and income statements show no income. Is that not the purpose behind an alternative minimum tax?
That is the purpose. The question is whether that's appropriate or a wise or fair policy. And that's, I think that's where the debate, and that's why I think I characterize that as it's a philosophical approach, or sort of a, what's the right approach to taxation policy. I wasn't trying to suggest that they were taxing regardless of income accidentally.
The other question I have is, we've been told that the single source will cost the state $18 million in revenue, but the package is more or less revenue neutral. Would you support the rest of the package if we didn't do the single source change?
Well, first of all, I believe that $18 million was kind of a rough early estimate, and as that financial impact, the losses and gains has been refined, I believe it's significantly less. I think it's less than half of that, such that the package that's now before you is more than balanced. In other words, I think it increases maybe $1 or $2 million in net. Also, in terms of, so we are, again, we really strongly encourage you folks considering something different on the AMT. But generally speaking, we are certainly in favor of the package moving forward, because there's greater benefit for Vermont corporations than harm, and I think it's going to be a positive change overall. Specific to you posing the question as to whether we still feel that way if the single sales apportionment was removed, that's the overwhelming part of what's positive with the bill. So not only would it be a shame for Vermont to not make that positive change, but then we'd be left with things that were included to try to offset that cost. And I kind of question what the sense would be of moving forward with this if that was not still the core and the heart of the bill.
Fair enough. So I assume that, I think I know the answer to my next question. If we just did the single source thing, that would be something you could live with, right?
Well, especially for some of the companies, or the kind of companies we're especially concerned about with regard to the throwback rule. Adopting single sales and not addressing throwback can have exaggerated negative consequences for some companies. It's a case-by-case basis. I would really keep those two provisions together on the positive side. And then all of the other provisions are either, just objectively, common sense tax changes, and/or help address some of the revenue concerns that folks may have. Really, at the end of the day, I'm not sure there's a strong argument for breaking apart the package. Again, we'd like to see maybe a modification on that one provision, but on the whole, the package generally makes sense.
So one final question, thank you. And I'm just using the numbers that I was working with. I understand you say that the numbers of $18 million may not be accurate or subject to change, but let's assume there's an $18 million loss in revenue to the state of Vermont if we go to single source.
Mm-hmm.
I understand that $18 million, it's been told to us that helps predominantly businesses that have greater nexus to the state of Vermont. They have more payroll, they have more employees, maybe less focused on out-of-state sales. So I'm just trying to get a handle. And then there's offsetting within that one change.
Mm-hmm.
There's some corporations that will lose out, and they're corporations that we wouldn't think have as much nexus to the state of Vermont. They may wind up paying more by going to single source. So I'm just wondering, is that $18 million, if you put the corporations into those two buckets, is it a much higher number than $18 million in how we're benefiting Vermont corporations that are the ones that have close nexus to the state of Vermont?
Well, again, and it might be worth revisiting with either Graham or the commissioner as to how those numbers play out. But I think the revenue impact of the single sales and market-based sourcing, just like Finnegan, moving from Joyce to Finnegan, or these other provisions, there are revenue losses and revenue gains, and the numbers that you have, which sort of pretty much even out in the score of this package, reflect both the increases and decreases for Vermont. Obviously we've been presented with the net numbers. I don't know what the positive and negative numbers are that resulted in those nets.
Okay. Thank
Generally speaking, one of the real benefit of this change is you're supporting companies that are employing Vermonters and have actual facilities and production here in the state. And you're shifting relatively that tax burden onto companies that are outside of Vermont and selling in. That in very broad, simple strokes, that's one of the major dynamics that you're doing here.
Okay, thank you.
Yeah.
Okay. Other questions for Mr. Driscoll? Senator Pearson.
Thank you. I guess my question is along the similar lines, and it has been hard for us to figure out each slice of this proposal. I think the updated estimate on the single sales factor was a cost of $11 million. And then that gets balanced out by some of the other ups, including the minimum tax.
Mm-hmm.
So, and I guess I feel I'm probably the inverse of where you're coming from. I would, absent other factors, be more inclined to support an increase in the corporate minimum tax and less inclined to give our corporations an $11 million tax break. But it does round out. And so help me understand, I guess, two questions. Looking alone at single sales, Vermont businesses have had benefits through the pandemic of hundreds of millions of dollars, taxpayer grants, and we've all sort of been pulling in that direction. So what would I say to somebody who says, well, why are you giving corporations an $11 million tax break if we were just talking about that? And then I guess the second or the related question is, if it's a win, you're suggesting it's a win for Vermont corporations that way, but then they end up paying a different way. Why? I mean, what's the benefit? I guess on net, maybe we're shifting who pays, but the bill is the same, right?
Well, so to work backwards, it's not a net on a taxpayer by taxpayer basis. You are sort of benefiting, supporting, rewarding companies that are employing Vermonters and investing in Vermont who are actually here and have a physical footprint, who are actually producing here and selling outside the state, bringing economic wealth into the state. The offsetting shift is more on companies that are generally not employing Vermonters here, not investing in Vermont facilities, but are selling into Vermont and have a taxable nexus here. So that's why it's a net benefit for Vermont from the perspective of Vermont. With regard to we should be doing this in the context of COVID-related aid and other things like that. I mean, I think a couple of things. One, yes, there was relief and support provided to Vermont businesses as well as residents and other things like that, because there were corresponding severe costs and harms that were being offset. So I'm not sure it's not as if COVID was sort of a net win for Vermont businesses during that time period. But then precisely to that point, the costs and the relief and everything associated with COVID is within the COVID context and the COVID timeframe. What this reform is addressing is the baseline, going forward. This would have been a great reform 2 years ago, 5 years ago, 10 years ago, and it will have been a great thing for us to have done 2, 5, 10, 50 years from now.
Okay, thanks.
Thank you, Mr. Driscoll. We are good. I've got Abby on the list, but Commissioner Bolio is, at least his name is here, and I think he may pop up shortly. There he is. And Commissioner, I know sometime today you sent some information over that was in response to, I think, some of the questions the committee had asked. And I thought I'd give you a chance to kind of present that.
Yeah, thank you, Madam Chair. I appreciate that. Craig Bolio, Tax Commissioner. So I've sent 2 documents. I think both are on the website, and I'll try to share momentarily here. One was in response to a question that you had, Senator Hardy, because I had mentioned that the Venn diagram of states that have single sales factor and market-based sourcing is almost near overlap, and you asked for an actual diagram. So we have produced one. And in addition, I think Senator Pearson, but I suspect others on the committee were also interested, and maybe it'll also speak to your question, Senator Sirotkin, about what does that compositional change look like on single sales factor? And we have isolated the top 50. I cannot provide you the top 20 because there's not an even number of winners and losers there. And so it would break our rules on aggregation, but I can give you the top 50. So let me try to share now. Apologies, I appreciate your patience. Okay. I am hopeful you're seeing a PDF diagram right now.
Yeah, there it is. Yes. Oh, and it's even in soothing green.
That we aim to please, Madam Chair. So this is, I think that this is hopefully a compelling document. As we had talked in my last testimony, Vermont went to market-based sourcing for services, and as you just heard from Mr. Driscoll as well, and many states have looked at single sales factor as sort of the next natural step after market-based sourcing. And so as we actually did the breakdown of which of these states have each of these policies, it felt rather compelling to me that on the left, you can see that there's half a dozen states that have single sales factor without market-based sourcing, another half dozen on the right that have market-based sourcing and no single sales factor, including Vermont. And then a whole bunch in the middle. I can't count it offhand, but quite a few that have both, including, all of our neighbors and almost maybe all of New England and New York. So, it really is sort of the next iteration of after market-based sourcing. And I think many states have seen it as the reflection of the new economy, right? One of the things that I was thinking about as I just was listening to the discussion and in response to your question, Senator Pearson, is that as the economy changes and we have more and more multi-state, multinational companies that are selling things into Vermont without necessarily having a presence here, single sales factor becomes less and less of a down, and maybe eventually, I don't know when that happens, but you could theorize that it would become an up if you had enough large companies that were selling into the state. So it really is. That's why I've been seeing it as a modernization. I'm happy if there are questions on this document to take any, or I can move to my other document that shows the impacts for the top 50.
Any questions?
I just want to say thank you. I love that diagram, and I agree. It's a pretty color. So yeah, thank you.
Yeah. This hour of the day, anything that is soothing on the eye after about 12 hours on Zoom is welcome. So let's hope your next one is soothing.
I
Should we
feel
throw
like,
some spaghetti at it, Madam Chair?
I think I went out of
Not
order,
yet.
Madam Chair. My next one I don't think is as colorful. But
Before we go there,
Yep.
are we, after this change, I should know this, but will we be in the both category?
Correct, Senator.
Okay. And in what sense will we be a blend? Because
I'm not
we
sure.
are moving to is single sales factor, but so what keeps us also market-based?
So those are actually two separate policy centers. So market-based sourcing is if you are a service provider, where do you apportion the sale of your service? And the old system was called cost of performance. So let's say you were an architect and you were providing plans for a building in Vermont, but you work in New York. Cost of performance, you'd source that to New York. Market-based sourcing, you'd source it to Vermont because that's where the market was. Then single sales factor says, okay, you no longer look at property or payroll in your apportionment factor. So that sale that you just apportioned to Vermont would become more impactful on the bottom line of your apportionment factor. Does that make sense? Does that answer the question?
It sort of makes sense. Yes, thank you.
Okay. So I think if I just click over here, I'm hopeful. Do you see the other document or do I have
It's
to?
up.
Okay, perfect. So again, this is the impact, the aggregated impact for single sales factor only. So not the entirety of the bill, just single sales factor
Okay.
on the top 50 companies under current law. And
Can you
the
make
one,
it a little larger?
I can try to do that. Absolutely. And I apologize.
That is much better.
I just lost my notes on my other screen,
Oh.
so I'm gonna fly by the seat of my pants and see how I do.
Okay.
So and one thing that I had caveated last time that I just want to highlight is obviously the composition of who's in the top 50 changes after single sales factor. So I just want to reiterate, this is the top 50 under current law and what the impact looks like for single sales factor. So I think Senator Sirotkin, this may also be responsive to what you were asking is, can we see sort of how the ups and downs just within single sales factor interplay? And if you look at really these top two rows, you'll see that within the top 50, there are 20 companies that benefit from single sales factor, and there are 30 companies who do not. I want to be very transparent about why the language is that way, is because the ones in the do not benefit column may be losers, so to speak, that their tax liability goes up, or they may be no change. And the number of no change in the top 50 is small enough that I cannot disaggregate it.
Okay.
So that's why those are together. But you can see that there are ups and downs just within single sales factor, and the impacts on the top 50 are consistent with the overall population that we talked about last time, which is that there are more who do not benefit than those who do, but the average impact for those who do benefit is larger than the negative impact for those who don't. And we have provided both the average and the median here. I know that was a discussion point last time as well. And I think the only other piece that I would highlight as you look over to the columns on the right side, again, both reflecting that the impacts here, well, certainly the impacts on these top 50 are large companies, right, by gross receipts. That's why they're in the top 50. But also reflecting, I think, a point Graham had made previously, that the data was showing that those who are benefiting tend to be smaller than those who are not benefiting. And that's reflected in both the average single sales factor tax due after the change. You can sort of back into the averages as they are today by adding up the average tax change and the average tax after, as well as those medians. So essentially, I think the bottom line that I would want to say is you have more who do not benefit than those who do, but the impacts on those who do benefit is on average larger, and that the profile of the companies who benefit are that they tend to be smaller than those who do not benefit, if that makes sense.
And more,
I think that's, oh, sorry, Senator.
I'm sorry for interrupting. But more importantly, or I don't know, more importantly, because helping small business is important, but more importantly, the nexus of the ones that benefit are clearly greater to Vermont, the nexus to Vermont is clearly greater for the ones that benefit. Is that correct?
Yeah, I mean, yes. I mean, I think you've hit sort of that foundational point, right? This policy will help those who have made the investments in payroll here and property here,
And
and
some
will
of the,
generally hurt those who haven't.
and some of those that will pay more do they have no nexus to Vermont? They just, other than selling goods to Vermonters through the internet or something?
Yeah, so some may be, there are a couple of different profiles. I mean, I think the easiest to comprehend is what you just described. Like if we have a company that is doing all sales, they have no jobs here and no property, they might see a significant increase in the liability from this. You could also, there are other elements of this bill that also help that, right? The Joyce to Finnegan swap, but you might also have, you know, a company that just has a small presence here, right? But they're selling a whole bunch of stuff either through some stores and the internet or something like that. But yeah, I mean, you're absolutely right. It's those who have made that investment get the help, and those who have not made that investment do not get the help.
Can you do a chart like this, not just for the top 50, but for all the people who pay corporate income tax?
So I don't have a chart for that, Senator, but in my last testimony, I did have this, well, I don't have graphs, I should say, but in my last testimony, I had this chart for everyone who's impacted. And I don't have those numbers right off the top of my head, but I believe in the total of corporate income taxpayers, there's about somewhere between 550 and 600 who benefit, and about 1,500 who do not benefit. And then there's a whole bunch, about 1,500 who could see their taxes go up. And then there's thousands more that aren't impacted by this at all, right? And that's because they're maybe all Vermont, or they don't have income in the state, something like that.
I guess the number I'm most interested in is the top line for the entire group. You say there's $11 million in savings for 20 companies. What's the total amount of savings in, you said 600 companies that benefited? What's that total in terms of savings?
Yeah, so I mean, if you could give me just a few moments, Senator, I could pull that
You're not
up.
going to answer it now. I'm just curious.
Yeah, I do have that. I mean, I also want to, I provided a caveat last time, and I don't mean to confuse things, Senator, but the JFO estimate and what tax is showing for tax year 20 are different. And so that's going to be a little bit different when you're looking at the fiscal note versus what we have. I could easily pull that number up. I would just need a couple of minutes to take myself off camera and go find that document.
You can just email that over to
Tomorrow
us.
would be fine.
Sure.
An email would be fine.
Okay, but this is also helpful. All right, committee,
Madam
any
Chair?
other questions? Yeah, is that Senator Hardy?
Yeah,
Okay,
I don't have a question on the chart if you want to take it down, Commissioner, unless somebody
Sure.
else has a
so
question.
someone else, any more questions on the chart?
Oh,
Okay.
sorry, I took it down.
I just want to, Senator Bray and I heard from our Economic Development Corporation, and I asked them for a list of companies in my district that they thought would benefit. And I don't want to name them all because it was just an estimate by our Economic Development Corporation. But the one that I asked you about, Commissioner, was on their list, actually. They are a C Corp. And so they actually were, it made me feel better because they're real businesses. They are not that top 50. They're not that big, but their estimate would be that they would benefit from the combination of the factors in this package. And, they are manufacturing businesses that have property and payroll in Vermont that sell a lot outside of the state, actually. So they have sales, but the sales are often outside of Vermont. So that sale wouldn't be picked up in the sales factor because they're selling something outside of Vermont, but they're a Vermont-based company. So it was nice to actually get a list of real businesses that seemed like they would benefit from this.
Okay. Any other questions for the commissioner? Okay, thank you, Commissioner. We've got one more bill to go through. So I think we're finished unless, are there other questions at this point on S53.
So actually, Madam Chair, I was able to just run those numbers as well to speak to your question, Senator Sirotkin.
Okay.
So for tax year 20, in the whole scope of things, we're seeing those that benefit in aggregate of about $18 million, and those who see their taxes go up in an aggregate of about 21 million. So the tax department actually sees this as an up right now, but I'm not disputing that JFO sees it as a down. We don't think it's actually an up. That's just what tax year 20 is showing us right now. But it's 18 million down in aggregate, 21 million up in aggregate, just from the impact for single sales factor.
And the projection we got from, I was working under the assumption that in a normal year, this would cost the state $18 million in revenue, just this one narrow policy provision.
So I think the latest fiscal note shows a projection of 11 million down, not 18 anymore. But
Okay.
the department doesn't dispute that figure with JFO.
Okay.
There's pandemic influence on corporate taxes this year. We don't have absolutely everybody in there, and we won't until later this year. So there are some reasons that the numbers we're showing are different from JFO's, and we don't dispute that.
But as a package, JFO's number went from a loss to, I was $1.67 million gain to the state.
That's right, because Joyce
You
to
lose
Finnegan
it here, but you pick it up in some of the other provisions.
Yeah, Joyce to Finnegan expands the base. Repealing 80/20 expands the base. Throwback rule, I still think will be a really small impact either way. So yeah, on balance right now, it's revenue up.
Okay.
I know I don't have to remind the committee the governor doesn't love the minimum tax.
Doesn't love that we,
The package right now is a revenue up with that included.
other than you muted, Senator, that is going to become my second banner on here. We are aware of that, but I am taking testimony on military pensions as sent to us by the other body.
Thank you, I appreciate that.
So the governor should be grateful. All right. So we're going to, Senator Brock.
Madam Chair, when we do get to military pensions, I have some folks who would like to testify, and I also have some written materials that would like to submit in support of that.
That is fine. And just get the names to Faith and we're going to take testimony. And I'm sure the railroad employees will be back in too. And we do have military, federal civil service. What I'm looking at is that for some of these pensions, state employees, teachers also pay Social Security, so they get both. My understanding is for both military and civil service. I know there were some big communities in Massachusetts. The first job I had, there was a town pension and there was no Social Security. So there's a few anomalies still out there, and I'm looking for equity. But we will take testimony. Senator Pearson.
Thanks, Madam Chair. Commissioner.
He's still here? Yep, there he is.
I think so. Every time we talk about this, it does not get more clear. Just from a straightforward, what your data shows is that 30 Vermont companies lose and 20 benefit. Why? Let's picture them all in the room. What do we say to the bulk of them, the majority of them that are losing? It's just, I feel like I must be missing something. Why would we favor a policy that that tends to benefit more Vermont companies, fewer Vermont companies than it benefits?
So I might tweak one thing you said there, Senator, which is that these are the top 50 corporate income taxpayers. These are not necessarily the top 50 like Vermont-based corporate income taxpayers, right? So our corporate income taxpayers are a mix of fully Vermont-based companies, are multi-state with some Vermont presence, are multi-state with only sales presence, right? So what this data reflects is that among our top 50 companies, there are more who do not benefit than those who benefit. So you asked, like, what if all 50 were here? Why would we say we are doing this? I mean, I think foundationally, the policy discussion that we need to have is what in the modern economy, what is the best reflection of income for corporate income tax, right? What this policy says is that where you are making your sales, where you are availing yourself of the market, and therefore generating your revenue, is a better reflection of your net income than is some combo of your sales, property, and payroll, right? And I think for many states, they've decided to make that change as the economy has changed, right? And as we have more large companies that are making a lot of sales into the state, it's essentially taking no action is essentially disadvantaging those who have decided to make that investment in payroll and property. So there's no dispute here, Senator. You might have some companies who have not made significant investment in payroll and property in Vermont grumpy about this change. You very well may have that. But you will also have a number of companies who have decided to make that investment, see this change as favorable. And so that's another major reason that I think states have done this. They want to encourage that investment, and they want to reward those companies who have made that investment. And those who have not yet made that investment may see their taxes increase, but this change also removes on paper that disincentive to do so, right? Where today they bring a job here, their corporate tax bill goes up. Under single sales factor, they bring a job here, their corporate tax bill does not go up, right? So I think there's a number of different ways to defend this on the policy side. It also has the fiscal benefit of generally helping those companies rather who have made that investment. And one of the pay-fors is that some of those companies who have not could see their taxes increase. Is that responsive to your question? I want to make sure I'm really answering it.
It is responsive. I've yet to decide it's compelling, but I appreciate it. Thanks, Sarah.
Okay, that chart was the top 50, assuming income corporations, right? It was not the top 50 Vermont-based corporations. I'm assuming in there might be one or two Vermont corporations, but
I'm sorry to cut you off, but in terms of tax paid in Vermont, though, right? Not like the biggest companies in the world.
Yeah, this chart is the top 50 Vermont corporate income taxpayers. So not necessarily Vermont based, but who's paying the most corporate income tax to Vermont under current law.
But when you think of it, payroll and plant are actually expenses. You spend money for payroll. We collect it in taxes, and you spend money to build and maintain a plant. I guess a plant produces product, which eventually becomes sales, but sales is where you make money, is when you sell. If you don't sell, you don't make money. I'm being simple, but okay.
But wouldn't we also say that payroll is a deducted expense, so reduces your tax liability, and investments in equipment and say
They're also deducted expenses, but you don't. It doesn't. It takes away from your taxes, but it doesn't increase your profit line. I mean, it interplays, but
it's also deducted federally, right? So it doesn't give you any specific benefit in Vermont. I mean, I guess maybe one of the foundational questions to ask is if you had a company that had $1 million in sales and 500,000 in sales in Vermont, and one of those companies had all of their payroll and property here, and the other company had no payroll and property here, do we think it's fair that the company that has no payroll and property here pays less in corporate income tax? That's what this bill is trying to address.
okay. We have to move on because we're now late. And we've got 416, and I think that's what Maria is. I gotta find my agenda. No, 166. Where am I finding 416? 166, and Maria is here for it. This is a quick walkthrough of the bill that got sent to us from Judiciary. It's utility construction work sites. Yeah, all right, we're recording. And okay.
I think that was,
Anyway, let's walk through it before we either start or stop doing something.
Okay, good afternoon, everyone. Maria Royal from Legislative Council, and I'm going to share my screen, if that makes sense. Okay, so yes, this is a bill that went to Judiciary. Judiciary voted out a strike all amendment, which I'm going to walk through now. It's not very long, as the chair mentioned, and then I'll just highlight some of the key differences between this proposed amendment and the bill as introduced.
Okay.
So in terms of the amendment by Senate Judiciary, I'll just read the purpose section because it gives you an overview. The purpose of this section is to protect the general public from harm or injury caused by unsafe practices related to utility pole attachments. I'm not going to go into detail about some of the stories that you've no doubt read about, but obviously there have been some injuries caused by steel lashing wire that was left behind when fiber was installed on some utility poles, and then specifically caused some real harm to a dairy farm in Tunbridge. So that's kind of just one instance that gave rise, and Senator Hardy obviously can speak more to her purpose of the bill. But in terms of subsection B, it basically specifies that an attaching entity subject to Commission Rule 3.700 that seeks to attach lines, wires, cables, or other facilities to a utility pole shall ensure that all construction contracts for such attachments contain terms and conditions specifying standards and responsibility for the safe disposal of any debris on the construction work site. So a couple of things I'll just mention. Attaching entity is defined in the rule, but basically this is any attachment to a utility pole. You've done work on in recent years, pole attachments. So any stringing of not only wires, but it could be wireless facilities, antenna, anything that goes onto a pole that's owned usually by an electric company or a telephone company. Those rules basically describe how much an entity has to pay in basically rent to attach their facilities, and also how the actual construction gets done, the process for that. So that's the scope. These are the attachments that are contemplated in terms of the scope of this requirement. It goes on to say that unless a contract specifies otherwise, the attaching entity is liable for all accidents, environmental cleanup, damages, or injuries to any person or property resulting from a failure to safely dispose of debris on the construction work site. So the idea here is private parties to a contract, they can assign liability, responsibility as they see fit. This is a default provision that if the contracts are not specific, that basically the attaching entity will be held accountable. But again, the intention is that all construction contracts will be very clear about responsibility and liability for performance, work performance and cleanup. So then in subsection C, in addition to any other applicable penalties or remedies, a person who violates the safety standards required by this section commits an unfair and deceptive act in trade and commerce in violation of, and that's a reference to a provision of the Consumer Protection Act. We'll talk about that a little bit more in a second. A person who sustains damages or injury as a result of such violation is a consumer for purposes of the Consumer Protection Act. So what this subsection basically does is provides enhanced remedies for injured parties. Under the Consumer Protection Act, a plaintiff is entitled to what are called treble damages, basically 3 times any amount of their proven damages, so more punitive. Also attorney's fees if they prevail in a court. The Consumer Protection Act also allows the Attorney General or the state's attorney in whose jurisdiction the harm or conduct occurs to investigate and potentially bring an action on behalf of a consumer. So these are additional remedies that would be available to a consumer who is harmed because of a failure to safely dispose of construction debris. Then the effective date and the application. The act takes effect on passage and shall apply to all construction contracts in effect on or after the effective date of this act. And the title is amended to more closely reflect what's covered in this amendment as opposed to the bill as introduced. So now I will just briefly go over some of those key differences, just so you're familiar with a little bit of the process. So one is, well, 2 big things. One, in the bills introduced, it basically required the Public Utility Commission to go through a rulemaking process to come up with the specificity for these standards for worksite cleanup. After discussion in judiciary, they decided ultimately to just put the standard or the requirement in statute and avoid going through the rulemaking process. So that's one big process difference. The other is the scope. Under S-166 is introduced. It referenced another rule of the PUC, Rule 3.5. And in doing so, it covered not just attachments to utility poles or not just telecommunications providers, but any construction practice and not just wires and cables, but any work that is done on the utility poles. So it could be quite broad. The Senate Judiciary decided that they wanted to more narrowly tailor the scope to communications attachments primarily. And so that was a decision that they made there. In terms of the Consumer Protection Act, making the conduct a violation of the Consumer Protection Act, that's very similar to the bills introduced. That remedy also was in the original bill. And the application effective date, the bill was effective on passage. I think there's greatest specificity in the judiciary amendment in that it specifically says that it does apply to any existing contracts. So that's kind of a quick overview. And what, do you have any questions for me or any?
I think that's a good overview. I've scheduled testimony for next week. And I think if I'm remembering what I asked Faith to do. We have had a contact from Jackie Folsom at the Farm Bureau, and I think we're contacting the injured farmers. So we can hear if we don't know what happened. And I've asked to have, well, we know who the affected PUC was, but also Christine to come in and talk to us about any issues they see in this rule. Listening to it, I think we probably have to have the public service and the PUC and maybe the Attorney General in. But I will go, I saw Senator Hardy and then Senator Pearson.
Thanks, Madam Chair. Maria, thank you. It's very interesting to see how it's changed. I'm wondering, does it still, I think one of the situations this was trying to remedy didn't involve wires, but involved chemicals. Would this still cover a situation like that?
I don't think it would, because that I believe that was a chemical preservative that was put on the utility pole, and then a container or bag of that preservative was left behind, and some agriculture, some goats got into that. I don't think that would be covered here because that doesn't fall within a pole attachment under Rule 3.7.
Okay. All right, thanks.
Okay, we can ask about that. Senator Pearson, swallowed the wrong way.
Thank you, Maria. I'm curious about the status quo. I kind of find it surprising that there isn't some level of blanket protection for somebody littering or whatever that has an impact. Is there do people sign something away when they allow right away, or could you just help me understand a little more about what the problem? I mean, I co-sponsored this bill. I think it's important, but it does, as I listen to you, it does surprise me that it's not sort of covered in some more broad law.
Yeah, so I'm actually glad you asked that question. I don't know how thoroughly I can address it because there's some things I don't know about the industry practices, but I think that I think there are a couple of things to note. This proposal I see more as providing enhanced remedies to something that might still be actionable under existing law, right? You know, I won't speak about the specifics, but there is a lawsuit right now pending that concerns the dairy farm in Tunbridge. So there was harm or an allegation of potentially negligence, you know, so there are remedies in place. Most construction contracts, you know, require that a job be done in a workmanlike manner. Presumably that would be interpreted as you don't leave garbage and debris on the work site. And if that causes harm, you're going to be liable. Most contracts have insurance provisions. There's, you know, these are private entities that are engaged in business that there's a real risk that something could go wrong. So usually I would presume there's coverage in most instances. And in that sense, people have a cause of action if they're harmed in some way. Who they collect from, how that process is, you know, so, and I think that's consistent with the testimony in judiciary, which is, well, you know, at least among some of the folks we heard from, you know, this is kind of covered in the contracts already. There may have been there might be some disagreements going on right now with respect to the Tunbridge incident. With respect to, you know, signing your rights away and easements, most utilities, if they're going across private property, they need to get an easement. And I don't think they do. I don't think they can, you know, ask the private landholder to waive their rights if there's some negligence committed, if somebody does something that falls below a standard that you would expect. So, and in fact, when Velco testified, if you hear from Velco, they'll do a much better job explaining how they handle things. But in general, when they're doing work across private property, they provide notice to the landholders. There's contact. So I don't know if it's fair to say that this is happening now and there's no remedy. There's a remedy, but people, I think, and I'm going to speak a little bit maybe, for the intent here is to make it very clear that this was a problem. It should never happen again. It calls it out specifically that it's in the contract, and so then it falls upon the parties to make sure to cover their exposure of any risk, because now there are enhanced penalties if they weren't already practicing safe practices. So that was longer answer than I expected to give. So I hope that wasn't too confusing.
I think part of the problem was there were remedies, but they had to work their way through court, and the farmers had an immediate expense that they needed to cover. They needed to find an alternative way to feed their livestock. And that's what brought this up. Remedies can take a long time. I can't tell you how many times I have typed in bids, clean and leave the premises as found. It's standard under, thank you for the opportunity to be of service. But that doesn't mean anything if you don't have some kind of insurance and something bad happens. Senator McDonald.
Madam Chair, I wrote Maria a question yesterday on this bill. In the Tunbridge case, this is what has alleged to have happened, that a subcontractor was hired to do some work on a telephone pole and hang some fiber. That subcontractor hired yet another subcontractor to do the work, and the subcontractor, once removed, littered the place, killed a few cows, and rendered a bunch of feed unusable. This bill does not seem to, and then the second contractor declared bankruptcy. So the law doesn't specify who is responsible when the littering takes place. And this bill does not seem to correct the situation of Tunbridge. It does not say that if the second contractor goes bankrupt, the first one owns it. And until that gets nailed down, we haven't solved that problem. That's my,
Okay.
and Maria Royale might comment that I'm, being a lawyer, haven't covered something, and share with us what I haven't covered.
Okay.
No, I think that let's see. I guess a couple of things. If you're just a point of clarification, you're saying if this situation were to happen again under this law
In the future,
in the future.
if it were to
Okay.
happen again in the future,
So in the future, if contracting parties comply with this law, then they are going to specify who's responsible for the worksite cleanup, who's liable, and what the standards are for worksite cleanup. That might not be enough specificity. If your question is, well, what if there's a bankruptcy? I don't know. Yeah, I guess I don't know enough about how that might be resolved among the contracting parties if there's happens to be a
well,
bankruptcy.
now in the absence of knowing how to do that, it would be solved in court and whatever the court concluded.
Right.
How could we, the legislature, set the policy so such thing would not have to go to court?
Right. And I
The folks
certainly,
would know about it before it happened.
absolutely. And it's definitely something to think through. And I certainly will try to do that. I think what's a little bit difficult about this is trying to apportion in advance liability, not knowing all of the different kind of circumstances or nuances. And,
Right.
but I'm happy to work with the committee to kind of flesh that out a little bit more and see if there are other standards that can be addressed in the language.
I think the danger here, we cannot influence what happened, a year, 2 years ago in Tunbridge. So we're writing a law to try and address that issue. But if we get too focused, we could find, and just, the absence of a word implies that the law is very specific. And if we need to do a law that is based on general principle, if we get too focused on this one situation, we could find out the next time there's a problem that doesn't quite fit the model for the law we wrote, we won't have helped it. So we need to kind of, I think, step back and say, what is the problem we're trying to solve? And we're trying to solve the fact that when something bad happens, and especially, and there are some industries where bankruptcy is more common than others, and subcontracting is more common than others. And how do we deal with that? How do we get the quickest remedy for the aggrieved party? And
You're correct, Madam Chair. And
Yeah.
I served on a committee that looked about a decade ago, that looked at the problem that when you subcontract someone else to do the job, that person should have to have the insurance, et cetera,
Oh,
et cetera,
yeah.
et cetera. And the question was, are they permitted to then further subcontract the job to someone else? Is that first party responsible for the next party or not? And
that
we
gets
were
into, that may get
not
into
capable
insurance law.
of setting that policy. Yeah, and of setting that policy. And this is what happens when we do not set that policy. And I would hope that we would not let this opportunity slip away again.
I think we're really in, that question is, if somebody hires somebody who hires somebody, and that third subcontractor or the second subcontractor does something wrong, and it turns out that that company doesn't have insurance, or that company declares bankruptcy, and they're in, and we probably should ask DFR an insurance question. What happens in that event to the insurance policy? It was active, in theory, at least from what I've heard, when the incident occurred. If they declare bankruptcy, what's the liability of the insurance company of that third person down? And if they have left their insurance lapse, does any liability fall back on the company that did the subcontracting? We could spend a long time on this.
You are correct again, Madam. You're correct again, Madam Chair, and we're not going to solve that now. That's the question. And
not
until we
today.
solve that question, we're not going to solve it. The rest of it is just talk, and we will have more incidents like what happened in Tunbridge and what has been passed. What this bill proposes to do isn't going to end that problem. So thank you.
No. And again, we have one incident and we strung a lot of wires. So, you know, I'm not sure but there are incidents in which we had the spilled chemical in which things happen, whether intentionally or not. And again, this gets down to who's liable and what remedy does the aggrieved party have. Looks like judiciary defined it as consumer, it wasn't fraud, but made them eligible for a larger swath of remedies than they ordinarily would have. That may not do what we want it to do. So we'll have the Attorney General in. We'll take I've got a whole bunch of lists right now. We need the utilities. Probably we should start with the broadband board and with public service and with the Attorney General's office, and then go from there. And maybe with the Public Utility Commission, and we'll see what we can learn. Okay. All right. It's almost 5. So I thank you. I think we had a good day, and we shall continue tomorrow.